turn the program over to Shawna Brown from our Alpha Parking, and we're very fortunate today because we have Sean is going to be joined by Taylor-Brophy and Chris Luongo in her remarks, and we're really privileged because anybody that's done probate, state administration, knows Lisa and Chris from the Surrogate sports, and they're the gatekeepers for anybody that wants to get anything done in probate court. So they are a wealth of information, and we're very thankful and happy for them to join us and share some of their policy experiences today. So with that, turn it over to Sean.
All right. Great. Does everyone hear me? Great. Okay. So I'm Shawna Brown. I'm an attorney in the elder law department at the Barrett. And I really wanted to talk this year about state administration, which is the name for the process of what happened after someone has passed away and basically someone has to wind up their life. I get so many calls from people who have recently lost a loved one or a friend, and they just have no idea what to do. They feel very lost, and they often are told inaccurate, very incorrect information. Friends, the internet, yes, ChatGPT will give you, and even things they watch on TV, like Susie Borman talks a lot about her things on CBS about probate and kind of tells people they need things they don't really need. It's just, it kind of becomes a mess. So I really want to talk about some of the common pitfalls of the probate process. I'm so lucky to have Lisa and Chris here today to pipe in with their frontline experience. We're so lucky in County Morris that we have Lisa and Chris who are on the front lines helping people every day going through really difficult situations and trying to simplify the process and be empathetic. Before I jump in though, I just want to say that the word probate has a very negative connotation. Everyone tells me, oh, I want to avoid probate. Oh my God, no probate. I don't want any probate. One important thing to keep in mind is if you're a New Jersey resident, probate is really not that taxing a process generally. Now, of course, Lisa and Chris know there are times where it can be more complicated, but generally it's a streamlined, fairly quick process. If you're in New York, sorry, that help you. I also practice there. That's a totally different ballgame. There, I would say, yes, please avoid probate, but we're going to focus on New Jersey today and talk about some things that the surrogate's office staff wishes you knew about the process. So, again, just to introduce the topic, probate is the concept of someone has died. Often they have a will, and you need to bring that will to court basically to effectuate their wishes. Because anything that person owns that's in their own name, doesn't have a joint owner, doesn't have a beneficiary, gets locked when they die. And to unlock it, you have to go to the surrogate's court, file an application, and get special keepers issued by them. Letters testamentary, that's what they call it. Have a will, letters of administration if you don't have a will, and that basically unlocks that and enables whoever's in charge of the estate to actually administer it. So that being said, we're going to jump into some pitfalls. At least the Brophy's going to be piping into this first section with her wisdom. All right, so this is probably one of the most important things is if you do make a will, which everyone in this room should have one, and if you don't, it's okay. There's still time. To probate that will, you really need the original document. That's really important. It's not impossible to probate the will if all you have is a copy, but it can become more costly because you may actually need a judge to approve the will. So, for example, if you have the original, you go into the surrogate, they process it, fairly streamlined process. If you have a copy, the surrogate's going to say to you, oh, we can't probate this. It needs to get the judge in the superior court to rubber stamp this. You're actually going to file a complaint with the court. And when you think about it, what if there is like a Chen's family situation and then he filed a complaint and somebody opposes it? You can see how that's going to go. That may take a lot longer and be a lot more expensive. So after you execute a will, which again, everyone should do, you should make sure it's in a safe place and whoever you're naming as your executor, the person named in your will and carry out your wishes and follow your instructions, make sure that they know where to find it when you pass away. You don't have to tell them what's in the will or even give them a copy. You can keep that private enough to your decision, but make sure they know where to get it. So Lisa, What's your whistle on the topic?
Again, my really, I mean, you basically covered it all. But the one thing is, you obviously, if you make a will, then attorney you should do. Even if you are an attorney, if you don't practice in this area, I would go see an attorney who knows what they're doing to create the will. Do not let that attorney hold up. Take the will with you, the original will, put it whether in a lockbox or a safe deposit box or a drawer in your dining room, cabinet or something. But don't let the attorney take it, because we've had many people. I think just this week, someone came in and said, "Oh, well, my father died. He had so and so grant his will, Bill deceased. He kept the original." Well, what happened to that will? I don't know. The law firm closed up years ago. We can't find anyone who has those documents. So now they have to report and probate the thing without the copy, but they only have a copy of the will. So it's just, do not let the attorney hold the will. That's my routine.
So we actually do hold wills in our group. We have a group will. But what we do,
Well, we've been around since 1931, so not too worried.
Lisa and I have had this role before. But we have a fire football, and what we do is we actually will stamp the copy with a stamp that says original being held by Mandelbaum Barrett, so that everyone knows where it is. But yes, I think safeguarding it is so important. And yeah, if you go to someone who's, is a little practitioner, that's a consideration. Another thing is, do not put your original will in your safe deposit box. When you pass away, somebody might not be able to access that quickly. Even if there's a joint owner, sometimes they need issues. So do not do that. So that's the most important thing. And also, don't let staple the will, get stapled together. I think we probably
I don't care.
don't care, but some courts do. So just don't do it.
Oh, and don't write on your will. When you have an original will, if you want to change something, go back to the attorney, either create a new will or do a copy so there's an addition to the will. Don't write on the will, because once it's written on, the surrogate can't accept that. Yeah. Even if it's the original. So we can't do that.
Yeah, that's a good tip. Don't try to fix the will. Not gonna work. So one other thing that I think a lot of providers don't know about is that sometimes the circuit will require the person who's in charge of the estate, the executor or the administrator, to be bonded. And I guess, but simply, a bond is kind of an insurance on the estate. The concept is, okay, executor, we're going to make you pay this fee essentially to get kind of an insurance policy for surety. And if for some reason you do something inappropriate with the estate, that bond is there in place to protect the beneficiaries. So the good news is that if someone's making a will, you can put in your will that your executor doesn't have to be bonded. Assuming you're picking a trusted person, they should be carrying out your wishes properly. So you can actually put in your will that they don't have to serve with a bond, and then the court will not require that bond issue. But at least you made an interesting point to me about if the executor doesn't live in New Jersey.
Maybe stuff in that. It's a statute. So if the executor does not live in New Jersey and the will is silent, so the will is silent as to bonding, and the person the appointed executor does live in New Jersey, they don't have to get bonded. But if the person is out of the state, the statute requires us to bond it. So then we need to figure out what the assets are. They have to post the surety bonds, and it'll be more costly and just more paperwork problematic. And if that person that you appoint your executor does end the credit, they're not going to get bond. So that's going to be another problem. That's all.
Now, of course, if someone does not have a will, there's no roadmap to say what's supposed to happen in that instance. So Lisa, how do you in Union County, how do you treat that with a bond when there is no will?
In Union County, everyone gets bonded unless they're a spouse, which you don't have to get bonded for a spouse. Even if you're the only heir, we bond the person. If it's a child or a sibling, a parent, they get bonded. If there are 2 or 3 or 4 heirs, we bond them. I mean, if they want to act together, we can have more than one person out, but everybody gets bonded. At least where I put. So other counties, every county is different, so I can't speak for other counties. But it's usually problematic when the one person wants to act because they live in New Jersey, doesn't have good credit, they can't get bonded, and try and find someone to be acquainted. It's tough.
Yeah, it can be a big pain. So it's something to think about. And again, the other is to take a will. So in a will, you shouldn't just say one person is your executor or on the topic of executors. It's really smart to bring back people. Just think about it. What if your executor dies before you? What if they, develop cognitive issue like dementia and they cannot serve? Or what if they just don't want to? This is a voluntary goal. no one is forced into becoming an executor. So if they are just like, I'm not up to it, what's going to happen? So you should name 1 to 2 alternate executors. I cannot tell you how many bills I've seen where somebody, one person, not the best idea. And then if at the end of the day, nobody survives, or no one wants to serve, then anyone who's called a residuary beneficiary under the will, you may get kind of part of the balance or where the balance of these assets in the estate, they can have the right to seek appointment. They call it an administrator CTA, which is just a fancy name for saying you will cut the executor, so you can someone else to serve. And then the beneficiaries have to agree on being appointed. That person needs to get bonded. And there's more recordings for it. So yeah, it's a great idea to name an executor and a couple of backup people. If there's no will, typically the next of kin are the people who are going to serve as administrator of the estate. So let's say in this example, Aunt Mary dies. She's not married. She has no kids. She has 15 surviving nieces and nephews. So they're closest relatives. So Lisa, are all those people going to have to get notice of what's going on and renounce to appoint somebody as the administrator?
Yes. And the problem with that is there's only, I haven't talked to that cousin in 10 years. I don't know where they live. That's not acceptable. We need to find out where everybody is. Everybody has to renounce. Everybody has to agree. If they don't agree, again, now you're banned from board. So again, this should all be avoided with having a will. But yeah, it's one of those things where it usually comes down to nieces, nephews, cousins. The cousins are the worst because it's first cousins once you're moved, first cousins twice. It just keeps trickling down the line. So, my first cousin's dead, so I don't have to worry about that. No, wait, your first cousin was dead, has 3 children. Now they have to renounce. Well, I don't fucks now. They live in Oklahoma. We have to go find out where they are in Oklahoma and get them to sign the. It's a lot of genealogy that's happened for.
Yes, definitely is. I'm actually going to skip the bonding slides here and talk about that. I'm going to touch upon small estate affidavits. Now, I don't see clients do this a whole lot. A small estate affidavit can be used in certain circumstances where an estate is small. So, for example, if the estate is under $25,000 or $50,000 in the event of a surviving spouse, yes, there's a more regulated process. So, Lisa, just quickly, could you tell me kind of what the pros and cons of doing that is?
So the pros are it's cheaper. It's $50, I believe, versus $135 for the administration. That's pretty much the only pro that I see, because inevitably you always find something else. So they'll come in, they'll say, my husband died, he just had a car in his name and a small bank account. It's only worth, 20,000 is the car, 3,000 bank account. We'll get the affidavit of surviving spouse. And then they'd say, I didn't realize he had this other SOP account that's 52,000. Well, now they have to come back into the office, get administration paperwork, costs more money because they have to get a 50, costs the extra. And it's also limiting because the affidavit is very specific. It lists literally the items that are in the state specifically. So there's a car, and as the car, the VIN number, and all the details. If you had an administration certificate, you have no details as to what the assets are. So if you find something else, you can, potentially use that certificate to go to the bank, to go to transfer a car. You can use the same certificate for it months. An affidavit is only for those specific items that you list. So it really does limit you as far as what assets you can and cannot obtain.
Right. So it seems that it's better to just get regular administration and just haul you up the fee. And just so you know, if you are the administrator of the estate, you can reimburse yourself from the estate's payment court fees. So, so that's just better to cover your bases. So thank you so much, Lisa, for your insight. Always appreciate it. And now we're moving on to kind of a slightly different topic that just long as them might be on you up this up here. Yeah. Oh, yeah, he's like, so Chris, when you and I spoke about doing this presentation, you said that, you hear from a lot of people who come in and have a problem with the person who've been appointed as the executor, and they always understand what their rights are, and also they have some waiting periods before they back. So why don't they tell me a bit about that?
Correct. The thing is with an executor, you can appoint anyone as executor because you want someone to pour credit, someone to like your job history, someone who's untrustworthy, someone cool as a employee. Because basically, there's no limit. Dude, it's almost like people. The only requirements to be executor in the state of New Jersey is that you're an adult and you have a pulse, and that's almost like it's like picking your spouse. Well, but unlike picking your spouse, when you pick your spouse, that's your problem. When you pick the executor, it's my problem. But that's basically do whatever you want.
Yeah, I mean, and I tell people, just pick someone you trust. I love when people pick one person instead of two, because sometimes if you pick two, you butt heads, and then that creates more problems, for attorney. That's the court.
Correct. It's much easier to pick one person than, as you mentioned before. It's also good to have a couple backups that are to serve.
So, Chris,
As far as the time limits, the law is that you're giving, when you get appointed as executor, you're given 6 months free reign, and you could basically, you're free from lawsuits during that time. And there's another statute that says you can't be compelled to account for 1 year, but there are things you can do during that time frame to help yourself if you don't trust the executor.
right, I can tell you how many calls I get, probably at least a dozen a year, from people to say, mom died, my brother's the executor, he doesn't talk to me anymore, he won't give me any information about his estate. I see him driving around with a new car. I can use his bumps money. We hear all these stories, and they say, "Well, isn't he supposed to tell me everything he does? And shouldn't we be having meetings about this?" And I say, "Well, technically, no. I said that would be good practice for your brother to share all things going on, but technically, at least in the beginning, they don't really have an obligation to tell you every step of the administration process, and you're surprised to learn that."
Correct. But there are things you can do, and I laid it out. There are a couple of statutes.
Okay.
Well, yes, Chico. There are some statutes you can use. There's a statute, 3B14-45. You can go to court and ask for discovery as to the assets. And you can do that at any time. It should be off the way 6 months. And you can ask for determine whether if there's real estate is insured, and whether there's the property tax and they pay. And then the next one is one yet. Oh, yeah. Just let me correct there. So you can, in addition, you can ask for an inventory of assets. You can ask for an account. You can have special clause, and you can actually ask for another fiduciary to be appointed to as well, which people don't usually do, but you can under what you usually got.
And it's not easy to get a fiduciary removed. I mean, I found that people say, "Well, they didn't give the information," or they're not nice to me, and that's not really a threshold. It's more along the lines I found of, somebody's like wasting estate assets or threatening to do that. There's such high hostility that they not continue in that position. But it's not that easy to get someone to remove.
It's almost impossible to remove an executor. The executor, if their causes are if they ignore a court order, or if they don't file the county, or they embezzle waste or missupply assets of the estate, or ironically, that's a basis for removal. But again, those cases are usually fought and contested, so you have to prove that someone has violated their oath as executor. So that's a tough standard, and if you can prove it, it's great. But most of these cases last for a while.
All right. So I find that a lot of people, get upset during a process, but they understand that through that accounting process, you have recourse at the end to say, "I want to see everything you've done, the entire history of the estate," and then you can actually file an action with the board to have them review the accounting and to object to it. So all beneficiaries have that right.
Correct. And that's about court process, and that usually is hiring an attorney. So choose wisely. Choose your executor wisely is the best thing I could say. But the penalties, the interesting part about there's very severe penalties for executors who misbehave. number one, you could lose your commissions. Number two, you can be fined. You don't file, you count the entire value of the estate. And number three, there's a statute 2A 625. If you misapply or misuse the state assets, you could be on the hook for triple damages. So between losing your commission, being fined for not filing accounting, or triple damages, are very significant penalties. So again, you have some leverage to your beneficiary, and I'm sure you're right.
Yeah, not good stuff. But luckily the court is here to help you with that. And any closing words on this topic, Chris? Anything
No,
you
just
yesterday or
choose wisely, and choose someone who's experienced. And just because you're the spouse, that doesn't necessarily be the best person. It usually is very ironically, as much as there's a parade of parables that happen, most of the time in the surrogate's office, I know BC probably feels this way 95% of the time, things are corrected because you were appointing your spouse or family member. Usually you see with each other. So, but
fingers crossed?
yeah, fingers crossed. Choose wisely.
Great. All right. Well, thanks so much, Elisa, Chris, for coming. I really appreciate your insight and your wisdom on this topic. Hey.